Members, good afternoon. It's already past 2:30 and we've also formed a quorum. May I call the meeting to order? The first item on the agenda is meeting with the administration. Please invite the administration to come into the room. Please note that the administration has provided responses to concerns raised by members at the last meeting on the 22nd of April and also the third round of questions from Mr. James To. Right, we'll talk about paper 973/01 and 925/01 responses to questions raised at the last meeting. 973/01, 925/01, and also 925. (925)(01). When the administration is ready, I give the floor to the administration to explain to us paper 973/01. Thank you, Madam Chair. Paper 973/1213/01 is responses to issues raised at the last meeting. Regarding responses to the Conveyancy Association and the Law Society, the administration, or rather the Bills Committee, would like us to provide a written reply to, but we are clearing with the DOJ, so I'm afraid we cannot give a very detailed response this afternoon, but we hope that a paper can be available as soon as possible on circumstances where a property owner has to purchase a second property because of reasons or factors beyond his control, and whether exemption can be granted. We need some time to discuss with the relevant government departments before we can come back to you. I hope we can provide a written reply within this week. And the other responses are rather straightforward. All right, please refer to paper 973/01. Refund mechanism for redevelopment activities. Well, I didn't see anything new after reading the paper. Is that true? Yes, all right. Implications of the BSD on the customary Chinese trusts under Zhou and Tong. Is it true that you haven't had any inquiries from stakeholders? That's true. Application of the BSD on usual mortgage. All right, no questions. Responses to deputations. Please report to this Bills Committee your discussions with relevant professional associations. Mr. Ibrahim Sheikh, why is it that after so many rounds of discussion and with so many requests and explanation, why is it the position is just the same? Why is the government so adamant, paying no heed to the voice of legislators and also the industry? And why does the administration feel that it is so right? Now, Mr. Wong Yok Man and Mr. Albert Chen are filibustering. I can follow suit. Do you want me to do that? So is the administration prepared to pass the bill because it has got enough votes? I think the requests by different stakeholders are very valid. In particular, there would be a problem of redevelopment. I think they are favoring the URA. Other associations or stakeholders have explained that this bill would make it impossible for other developers to carry out redevelopment projects. Administration, no, this is certainly not our intention. We really want to have the support of members. Regarding the BSD refund mechanism for redevelopment activities, we are indeed considering views from administrations, but we have to ascertain the government's position, and we have provided a written reply to members' concerns, and we are still considering various views from members and also the industry. Now, it's not that we are complacent, that we have enough views to pass the bill. We always want to garner as much support as possible. Well, I don't think it's fair to Ms. Wong, given that she is just an AO, and we want to meet with the Secretary for Transport and Housing. Whether we are right or wrong, we would want the Secretary or Undersecretary to come to explain. I have to apologize, Ms. Wong. I might have put you in a difficult position. It's not my intention. You cannot represent the Secretary in making such remarks. The Secretary owes us an explanation here. I have asked him to be present. When will he attend our meetings? Well, members' wish is very clear. We want the Secretary to be present here to explain to us the administration's position. So through the Secretariat, we'll formally invite the Secretary to meet us. Is the date fixed? No. Not to the panel, but sorry, to the Bills Committee. As soon as I am aware of the date, I will notify members. I promise that we will strongly request the Secretary to meet with the Bills Committee. He has privately told me that he is happy to attend such a meeting, and we're in the process of arranging it. Well, I really want to commend your leadership as the chairman of this BC, but I think it's a waste of time if we proceed to a clause-by-clause scrutiny. Now, if his position is cast in iron, he's not going to change the position. What's the point of his meeting with us? Now, if he or Siwa Leung wants to show clear or strong governance and is not going to change his position, well, I've sent this very clear message to the Secretary that before we start our clause-by-clause scrutiny, he should meet with us. The message is loud and clear, and it is for the Secretary to respond. Ms. Wong, yes, we have clearly conveyed your message to the Secretary. He is willing to meet with you. We are just trying to fix a date. The Secretary is very willing to meet with us. Well, that's very clear, yes. Well, that being the case, why don't we stop the scrutiny of the bill and pending a clear explanation from the Secretary? That I beg to differ. Ms. Chen Yunhan. I really agree with Mr. Abraham Sheikh. But it's taken so long for the Secretary to meet with us. This is a problem. Since we've asked for him to meet with us for so long, why has he taken so long? We cannot wait indefinitely. We are now vetting the bill, and how much longer do we have to wait? I agree that he should be here as soon as possible. Noted. But you have to give us a date. Well, previously we were stuck in the filibustering, so I have communicated this to him as my personal request that he be here before we start our cross scrutiny. Now, this is not personal, Chairman. Many of us were also caught in the filibustering, but we're here this afternoon. The Secretary wasn't involved in the filibuster, and how come he can't be here? I support this objective, and I think he owes us, as well as the market, an explanation. The industry as well. Mr. N. Shek.
Since Mr. Shek would like the Secretary to come and explain all these issues to us, perhaps after the meeting, Madam Chair, you can liaise with the Secretary and ask when he will be able to come. Madam Chair, if you put the request to him, I'm sure he will give you, a definite time. I will personally call him up after the meeting and ask him to make an appointment. Madam Chair, please do that as soon as possible. Point taken. We still have a few more papers that we have to deal with yet. So let's go through some of the papers that we haven't gone through yet. Let's now go back to paper 893, bracket 2. And this document are the responses from the deputations. I think we stopped at para 31 the last time. Can you find the paper? I'd like to remind members that according to our rules of procedures, members would need to declare whatever interest they may have. I declared that I owned property myself. I'm a professional accountant. I also practice in tax consulting service, but Mr. Shek, I declared that I represent the Real Estate Developers Association. I own properties. I'm also I sit also on the board of listed companies, some of which are property companies. Ms. Chen Yun, I also own properties. Mr. Wong Ting Kwong, I declare that both myself and my company also own properties, but I don't have any plans to for any property transactions in the short term. Mr. N. I think I would make the same declaration to Mr. Wong. Mrs. Yu Si-wing, I'd like to declare that I also own the property in which I live in. Mr. Chen Chi-wai, I family also owns properties. Mr. Andrew Leung, yes, both myself and my company own properties. Mr. Poon Siu Ping, yes. Mr. James To, I also like to make a declaration that I also own a property. So when can we ask questions? We're now looking at paper 893, bracket 2, and we're now at paragraph 31, the Hong Kong Association of Banks. The liability to pay SSD should rest with the vendor solely, or if this is not accepted, any additional SSD due to any inadequacy of the state consideration should be payable by the vendor solely. Administration, could you give us a response to the submission from the Hong Kong Association of Banks? Madam Chair, the stamp duty, according to the 16 ordinance, is that it's a tax liability which is a joint and several liability. So the principle here therefore applies to the transactions on properties. 32. Appropriate provision should be included in the bill to clarify the liability to pay any additional SSD, should not create any encumbrance on the residential property or affect the title to the residential property, or alternatively to provide for protection to bona fide purchasers, including mortgagees, for available consideration dealing with residential property. And you do not accept this. Well, according to our understanding, the Association of Banks' concern is whether or not they will have a liability in the capacity as mortgagees. when we launched the SST in 2011, this has already happened. But looking at the records so far, we have not seen such a situation arising. So we do not see, therefore, that this is a major problem. Mr. James, so I don't quite understand the answer. So does to put it more plainly, the banks are worried that if the bank has to shoulder the responsibility, is the administration now saying that according to the bill, they don't have to bear the responsibility, or should they also bear the risk and the responsibility? Perhaps I'll ask our colleagues from the IRD to answer the question. Thank you. Well, the SST, the liability to pay the SST since the bill became act in 2011, both parties to the transaction will have to jointly and severally liable to pay the stamp duty. Last time, someone suggested that the vendor may stipulate the value of the property in the contract which is less than that of the market value, and as a result there is a shortfall in the stamp duty paid. At the last time when we scrutinized the bill, we said that under subclause 40 we will be able to correctly, within 14 days, obtain information from the RSD to ascertain the proper value of the property, so that we will be able to find out the real value of the property and charge the stamp duty accordingly. So the scenario of underpayment of the stamp duty is not very likely, and we've not seen any instances where we have to recover, any stamp duties which have been underpaid. Mr. Abraham, over the last 2 years, there have been about 1,800 transactions for which stamp duties have been paid. It's amounting to $180,000. But despite what you said, I don't think the scenario may not arise. The Association of Banks question is now asking you this because we would like to know what is the procedure. And I don't think you've answered the question. Very often you refuse to answer many questions, but that doesn't mean the question does not exist. Could you give us an answer? Could you give an answer to the Association of Banks? Because many property owners, many vendors and purchasers are involved. The market would need to know, the laws would need to be clear. As legislators, we can't say, let's bury our heads in the sand and wait and the problem arises. The same happened to the Land Titles Bill. And that's why the bill is still not, has not become law. So we need to be given the answers. But should there be any litigation in future, what should we do? Would they need to come back to check the Hansard? And they may find out that legislators are willing to accept the kind of arrangement. I am also part of the pro-establishment camp, but as a legislator, I also have a duty to ensure that the legislation we pass are clear. Any further supplement? Mr. Wong, under the existing ordinance, we're talking about the joint and both the buyers and the sellers are jointly and severally liable to pay the stamp duty. And the instrument, I think if should there be any shortfall in the stamp duties paid, then the parties involved will have the responsibility to make up for the shortfall. The intention here is to ensure that no one will pay less stamp duty, as a result of which the entire Inland Revenue mechanism would be jeopardized. There are already other mechanisms available, so that within a very short time we'll be able to ascertain the final amount of stamp duties payable. We would also want to help the parties to the transaction to know the amount of stamp duties payable so that we can allay the concerns of the market. Okay, let's move on to 33. 33 through, well, I think these are still issues raised by the Association of Banks. 33. The wording of the proposed section 29 dB bracket A bracket C of the bill is inconsistent with item 6 in question 9 of the FAQ on IRD's website. What is the response here? Perhaps I'll ask Mr. Wong from the IRD to give members the detail. Perhaps Mr. Wong can supplement. Mr. Wong? As we've said in our written response, the Association of Banks, after looking on our website, claims that there is a discrepancy in the wordings used, and we don't agree. According to our IRD's website, the acquisition of a mortgaged residential property under a conveyance by a mortgagee or a transfer of a mortgaged residential property will not be subject to the BST. It is consistent with Section 29 dB bracket A bracket C. 34. No express requirement under the proposed Section 29 dB 8 bracket C of the bill that the mortgagee referred to in that section must be the same mortgagee of the mortgage property. For 33, I'd like to ask our legal advisor whether or not this is consistent with the law. Well, I don't have anything further to supplement in respect to this item. But in this chart, sometimes I said the government will consider making a suggestion or seriously consider the suggestion. For example, for 32 and 34, in response, in relation to these responses, will the government be providing further CSAs? Would it let us know about the outcome of their further consideration? Does the administration have any timetable? You say you will consider these issues. Well, after we've further considered these issues, should there be any further ambiguities? And if we need to further clarify by way of CSA, we will do that. So for 32 and 34, we will now await the final response from the administration. I think regarding 32, we've already explained that after considering the issue raised by the Association of Banks, we do not think that there is a major problem here. For the others, if there is indeed a need to clarify certain matters, or if our drafting could be further improved, we will later on draft some CSAs for members' consideration. The same applies to 38, right? Perhaps later on you can report back to this Bills Committee about your final decision. 34 and 38. Mr. Chair, 32, 34, and 38. Before we go to the clause-by-clause scrutiny, it would be best if they could give us their responses so that we would know how to proceed. Because during the clause-by-clause, I think sometimes we may need to look at several clauses together. So before we go to the clause-by-clause, could they give us all the answers? If we don't press them, they wouldn't give us an answer. I think we're just about to proceed with our clause-by-clause. So when will you be able to finish with your consideration? Members would like to have a response from you before we go to the clause-by-clause. Okay. Next, we now move on to 35. The government should provide examples which come within the scope of exemption provided under 29 dB 8 bracket C. What is your response? Again, Mr. Wong will explain this to members. Thank you, Madam Chair. Regarding para 35, that is, under what circumstances would the mortgagee when the mortgagee would enjoy the exemption? I think we are making reference of the previous stamp duty ordinance. That is, if the mortgagee is a financial institution, then if it is a financial institution according to the definition of the IRO, and in a situation where the mortgagor is unable to repay the mortgage loan and transfer the mortgage property to the mortgagee, which is a financial institution, then no stamp duty will be required. Legal advisor. Nothing further. Okay, 36. To align with the proposed Section 29DB bracket 8 of the bill, an equivalent provision should be added to the proposed Section 29CB to exempt an agreement for sale from the BSD. If, under that agreement, the mortgage property is sold for a mortgagee, what is the response? Administration. Well, actually, the mortgagee is, we're talking about a mortgage property, and we do not think that there is a need to add the proposed, the suggested provision to the bill. Mr. James To, I think for clause 36 is rather unique, because let's say you have a mortgager who mortgages his property with the bank, but now the property is being sold to the bank. I'm thinking about a possible scenario. The government said that only this scenario would happen. That is, you have the mortgage property being transferred by way of conveyance. And in which case you will still charge the additional stamp duty. Is that what you mean? I don't quite understand your answer. You say we understand that the mortgage property can only be acquired by or transferred to the mortgage by way of a conveyance. Are you treating the banks the same as you would treat the buyers, and that you only exempt those who sell the properties to a third party? Let's say the property is not being auctioned and the bank decides to acquire the property. Of course, they can also acquire the property through a receiver, and the mortgagor also agrees. Well, in this case, could there be an exemption? Are you worried that there might be collusion between the bank and the mortgagor? You say that someone would collude with the bank and then buy a property. I don't think that's very likely, unless the bank would like to buy a short premises to operate the bank office, and first of all, they would ask the owner to pretend to mortgage property to the bank, and then he pretends that he cannot make the mortgage payment, so that the bank subsequently acquires the property and use the premises to run a bank office. Is that the scenario that you're worried about?
Under Secretary, Deputy Secretary, I defer to Mr. Wong. I think the HCAP question is about buying that property from the mortgagor. Now, because the mortgagor is not able to pay back the mortgage, so under the mortgage agreement, the bank will acquire the property by way of conveyance. Under the conveyance or under the mortgage agreement, the bank is not going to buy that property. It is just exercising its right under the agreement to acquire the property, not by buying. So we don't believe it is necessary to amend the bill to allow the bank to be exempted when buying that property. Of course, 99 of 100 cases will be like that. If the mortgagor default, then the property has to be auctioned. But I think it is referring to a very rare case. For instance, no one buys that property and the bank decides to buy it itself. Is it allowed? Assuming that the auction is under the mortgagor or the property owner's name, though the arrangement is made by the bank. The bank has got an authorization from the mortgagor and then no one responds in the public auction, and then the bank decides to buy it rather than leaving it idle. So it is already a transaction. Can that transaction be exempted? I think that's what this is all about, although it is very rare. So for usual mortgages, the bank is exempt from paying BSD. So Mr. To has just quoted a case. Have you thought of this scenario, Mr. Wong? As I said, under the deed of mortgage, the bank has to exercise its power of sale. It is entitled to do that. There is no need for the bank to buy the property first. Don't think that's the case. If you mortgage your property to the bank cannot automatically become the property owner. I don't get what you are saying. Now, if the bank has chosen to buy that property, then there must be a deed of transaction, deed of assignment. So the bank has bought the property and not selling it to a third party by auction. I do agree that this is very rare. Usually, the bank will ask a receiver to auction the property and is exempt from paying the BSD. I'll ask my colleague Mr. Hong to supplement. Yes, the bank has taken over the property, and then an assignment is done in order to for the bank to acquire the property, and that is already exemption under 29C. No, Chairman. Please explain to me why there is an exemption there. Because the mortgagor has owed the bank money, so the bank is forced to take over. The bank is not a permanent resident of Hong Kong, and therefore BSD is chargeable. So we provide an exemption under the bill. So the administration is saying that 29 DB8, as mentioned in 36, is not applicable. Rather, Section 29 DB8 will be able to address the concern raised under point 36. Am I correct? So, according to the administration, if indeed a mortgaged property is sold to the bank, then Section 29 DB8 will be sufficient for the exemption of BSD. Section 29 DB8C is about a conveyance where the bank is the beneficiary because the property owner has defaulted in mortgage repayment. And so the bank has become a mortgagee, and there is exemption under this provision. No, HCAP has raised such a technical point. Do you get what the bank is driving at? If you don't, why don't we ask HCAP to explain to you further what 36, point 36 or point 35 is about? Now, you can say that, well, there is no need to amend Section 29 CB because Section 29 DB8 has sufficiently addressed that issue. Is that your answer? Which one, from the administration? Regarding views on implementation details of stakeholders, have asked the administration to communicate with them directly, and we hope that they will be satisfied with the administration's responses. So please report to us after you have addressed these technical questions raised by HCAP. Ms. Wong, we will provide a reply later. Yes, for technical issues raised by organizations such as the Law Society, we are making arrangements to meet them. I think the Law Society and HCAP are mainly involved in the operation of the bill. So please communicate with them and let us know the outcome. Point 37, Mr. Abraham Sheikh. I think for point 36, HCAP has expressed itself very clearly. And the answer has oversimplified the matter. I will not repeat the question asked by Mr. James To. The response has failed to answer HCAP's concern and whether 29 DB8 can be aligned with 29 CB. Because the answer we get is that all the power rests with the IRD. Mr. Hong from IRD, please. Let me clarify. I think there's a misunderstanding of point 33. HCAP is of the view that a mortgaged property acquired by way of conveyance can be granted exemption, and they're saying that perhaps there should be amendment to propose Section 39 CDB to exempt an agreement for sale from BSD. Our understanding is that usually the bank would not acquire property by agreement for sale, but rather by way of conveyance. So we believe for the time being there is no need to amend Section 29 CB in a similar manner. Mr. James To, now I am not in the banking industry. I am thinking of this possibility. A mortgagor is not able to repay its mortgage, and yes, the property can be sold to the bank. It's true that an assignment can be directly made, so the property is acquired by the bank by way of conveyance. What if the bank says, well, let's not do it by conveyance so soon. Why don't you sign an PSA first? And then the bank is able to sell that property through an agent subsequently. And the bank don't want the S&P to be chargeable with BSD, and that's why they want you to provide exemption for S&P as well. In fact, the bank is acting as a conformor. The bank doesn't want the SNA or the agreement for sale to be charged with BSD. So there is this slight possibility. You know, banks would like to have the best of all worlds, and the bank doesn't want to pay BSD for an S&P when the transaction or the actual assignment may take place long afterwards. So a property cannot be disposed of by auctioning, and then the bank would like to make an S&P first. So there is this possibility. Do you understand Mr. James To's view? So, as requested, please discuss with HCAP to ascertain their concerns. I hope they can accept your clarification, and if so, please report to us later. Yes, while we cannot rule the possibility of the scenario quoted by Mr. James To, but usually banks don't have to do that in such a indirect manner. But we'll discuss with HCAP to see whether this is their genuine concern and see whether an amendment is needed. All right, point 37. Your The government should confirm that neither the bill nor any administrative measures will seek to impose additional legal duty or obligation on the banks to verify the Hong Kong PR status of the purchasers or mortgagors. Please briefly tell us your response. The essence is still for the buyer to make a statutory declaration. No banks or no lawyers will have additional legal duty or obligation to ascertain their status. So, because the purchaser knows whether he is a permanent resident by just looking at his own ID, this is a fact. He can ascertain easily. So we will not impose additional legal obligation on banks. All right, point 38. Mr. Sheikh, I thank the administration for explaining that declaration can be acceptable. What about Hong Kong companies and Hong Kong permanent residents? Why can't declarations from companies be acceptable? According to administration, a company is a separate entity. So why is it that for companies, statutory declarations are not acceptable and yet it is acceptable here? I think the administration should accept declarations from directors as well.
Mr. James Toh, I think we need to have consistency here. If somebody were a permanent resident and you ask him to make a statutory declaration and you accept the fact that he is a permanent resident. So if you have a company, the directors of which are all Hong Kong, all the directors make a statutory statement saying that they are permanent residents. They may even declare for how long they've held the shares of the company. So conceptually, this is a declaration with legal consequences. If that is, the person lies, he will be in prison. If you're able to accept this arrangement, then at least you cannot refute this. Policy is something else, of course. As a matter of formality, you can prove that. Whether or not you accept permanent resident selling a company is one thing, but at least you cannot use this as the argument and say that the other statutory declaration is not serious enough to prove the fact. I think you should. I think what Mr. Sheikh and Mr. Toh's points are very clear. Could you please go back and consider them further? I'm sure when the Secretary comes, you will ask him the same question. Chairman, other than making the statutory declaration, the person in his person, I think it's easier for the IRD to find out whether or not that declaration is true or false, so long as he submits a copy of his ID. The IRD can already prove whether or not the declaration is true or not. Whereas in the case of company, the company can result in different ways, so that the declaration, statutory declaration, and whether or not and when we verify the statutory declaration by the company, the procedure is different. I think the extent of verification, that is what the company registry says. If, let's say, during a period of time, the person is not a shareholder of the company, or if he is a shareholder, that already, if the person makes a statutory declaration, I think you can check that. I think we've mentioned before that there are many instances where the transfer could be done by way of nomination, placement of new shares, and so on. So the shares could be transferred, and sometimes not so easy to identify that. In some cases, they don't need to report to the IRD, and in some cases, even the company registry may not know. So we're now saying that it's not so easy for us to verify all that, because there are many ways for the company to transfer its shares, and I'm sure members are even more aware of this than we do. Mr. Sheck. Of course, Mr. Sheck understands this. That's why we asked you the question. We have a duty to tell you. I mean, you pay the salary, and you pay a much different salary than electrical members. We have raised the issues, and I don't think you should say that it's difficult for you to pursue this, and therefore you're not going to do it. I think members' points are very clear. Anything further from the administration? Well, Madam Chair, well, perhaps I can give an example here. Let's say somebody by the name of Lai, Mr. Lai, once acquired the status of a Hong Kong permanent resident, and subsequently the government, cancelled his status as a HKPR because he obtained the PR status through a single one-way permit. Let's say you have such a resident who's made a statute declaration. How would you deal with that eventually? For the tax that you wish to recover? Well, of course, first of all, you have to find that person, and secondly, the person whose PR status has been revoked, you will still go after him, right? Let's say I buy a property from a vendor. He made a statute declaration. I sell my property to him. That's the end of the story. And subsequently, he was in prison. He might even have committed suicide while I continue with my own business. And later on, if his PR status were revoked, then I'll be held liable for the special stamp duty, which should have been paid earlier. Let me start, and Mr. Wong can supplement. I think our position now is that at the moment you make the statute declaration, if you genuinely, state the facts, let's say on the day in question, there's no problem with your ID card saying that you are a Hong Kong permanent resident. At that moment, you genuinely believe that you are a PR, and you made the statutory declaration. And because of that, I'm exempted from the BSD. I don't know, many years later, the scenario you depicted happens. Well, first of all, he did not make a false declaration, so there's no criminal liability here. It was not a false declaration. I think what happened only happened afterward, after the declaration, and because of that, we will not recover. We will not ask him to pay back the BSD. Mr. Wong, I think what we are considering is that in the stamp duty ordinance, it is also provided that the condition for exemption is the one we need to have a Hong Kong PR status. As Madam Wong said earlier, if the person make a statute declaration in good faith, and he genuinely believes that he's a PR, then it would be fine. But in a different scenario, let's say he made a false declaration, of course you have to shoulder the legal consequences. But that is only restricted to the vendor, and it will not affect the purchaser. Will this be in the draft, or we are going to draft this? Okay, I'll mark this down. 38. Madam Chair. I think 38 is different from 37, but if you want to recover the stamp duty, let's say he bought the property for $1 million, and when the IOD tried to recover the stamp duty, it's already worth $10 million. So what's the arrangement that that would apply in this case? Now, who would like to clarify that? Mr. Hong? Or Madam Wong? Mr. Sheck, could you explain your scenario more clearly? I think originally some stamp duties might not be in charge. Whatever the reason, because of a time gap, and then meanwhile the property value has gone up, and are you going to charge 15% of the value of the property at the time it was bought, or 15% of the value of the property at the time you want to recover the stamp duty. Chairman. One of the basic principles for stamp duty is the time of transaction. Stamp duty is charged on the day in question. If the transaction is done on day one, we will consider the value on day one. If it was transacted for $1 million and in year 10 it's appreciated to $10 million, we will still charge the stamp duty according to the value of the property on day one. Madam Chair, I want to put this in the minutes, record this in the minutes. Could you further spell that out? The basic condition for the payment of stamp duty is that we would decide on the condition at the time the transaction was done to determine whether stamp duties would need to be charged and how much. Should there be any underpayment or anyway, you would recover the stamp duty according to the value of the property at the time of the transaction, unless the value of the property is being challenged. Mr. Chair Wai Chin, I'd like to clarify what's the meaning of transaction. Do you mean the signing of the S&P contract? It will depend on the instrument, the date at which the contract, the agreement was signed. If it is an S&P contract, then it would referring to the date the contract was signed. If you have both, which one will you take the earlier of the two dates? If we're talking about the BSD, if there is a provisional S&P contract, and within 14 days the formal S&P agreement was signed, then we would look at the date the formal S&P agreement was signed. What about the day the transaction is completed? So if there's a S&P agreement, then you don't have to pay BST in respect of the conveyance contract. Would that be okay? So for para 38, Mr. James To? I think Mr. Wu Chi-Wai has a question. Thank you. Madam Chair, I note that when several deputations raised questions, the government said that they do not accept the evidence, but then the government also said that they will take note of the comments made by the suggestions and consider the suggestions. Does that mean that the administration will incorporate these suggestions into the text of the bill? Well, we've said earlier already that the government will give us a response before we go into the clause-by-clause scrutiny as to whether or not they would come under the CSAs, including Section 38. Yes, we still need time to further consider the issues raised by the deputations. In those areas where we need to further clarify issues, we will do so, provide the clarification by way of CSAs. We'll also explain to the Bills Committee the final outcome of our consideration of these issues. Could the administration, when you give us a supplementary paper, please provide a list of the points that you've accepted and those that you have not, and tell us how many CSAs will be forthcoming. Right. Mr. James To, Madam Chair, have we covered the topic of redevelopment? We haven't touched on paper 03 yet. I think we've been discussing the issue during the last two meetings, and the administration earlier just told us that they have nothing new for us meanwhile, but the Secretary will come to meet with us. I think we can let them go back and consider this further, let the Secretary consider this further. Even if I agree with your basic opinion about this new form of tax. The 6 years requirement is not really necessary. Of course, you can, enlighten me further. But let's say if you consider, say, a longer period of 10 years, we're talking about 4 extra years, and you say you might be worried that the tax or the stamp duty, I think you need to go through all the administrative procedures of making the records and making refunds and so on. And you say that it will affect the annual government revenue. How much refund are we talking about here? We're talking about several hundreds of billions of tax revenue every year. So that definitely should not be the reason. So please think about this carefully, and when the Secretary comes to answer our question, give us good justification. Otherwise, we will still have the impression that the government is simply insisting on its own position. You say it should be 6 years, but 6 years is not a magic figure. If you want to encourage redevelopment, I think if the developer has to wait for 10 years for a refund, that would be disaster. So I don't understand why the administration is still refusing to budge. So even if you wish to insist on this, please give us a better reason. Otherwise, it's hard for us to accept that. Madam Chair, if I may ask Mr. To to further clarify his point. Mr. To is saying that 6 years is too short. I don't understand Mr. To's point. Mr. To, are you saying that there is no objective criteria to decide it should be 6 years? Let's say for redevelopment, it may take a long time to actually acquire the properties. I don't know in the past how many redevelopment projects were able to be finished within 6 years. We have, according to my understanding, it's not easy to complete a redevelopment project in 6 years. If you want to encourage redevelopment to be completed in 6 years, if the amount of tax involved is substantial, then the redeveloper may try to elicit support of trias to forcibly evict the tenants in order to expedite the redevelopment. We're talking about the rebate of a single stamp duty. We're talking about a lot, and in the end, triads will be involved. And otherwise, how can you do it in 6 years? I mean, what you're suggesting may provide incentives for this to happen. And for the landlords of the old tenement buildings, this is a risk.
No matter how strong the police are, it's useless because we're talking about money in the form of BSD. So if there is no abuse, if it will not affect your revenue, then why do you have to keep it so short? Can it be longer than 6 years? Well, for 6 years, we disregard the time for acquisition of previous properties. We'll talk about the last property. Some members even say that 6 years is too long. So the 6-year period will only start counting when the when the developers become the owner of the entire lot. So from the completion of acquisition to the first occupation permit. So most members said that it would substantially add to the cost of redevelopment, and we wanted the administration to shorten the period, and perhaps redevelopment BSD can be chargeable too. Mr. Sheck. Mr. James To knows very clearly what he is asking, and you don't, because James has been a member of the URA for more than a decade. We work together in the URA. In an old urban area, it takes at least 10 years. Hopewell, took 20 to 30 years to acquire a lot in Wan Chai. Well, 10 plus 6 years, that's 16 years. So the money can only be refunded after 16 years. Please consider the compound interest involved. Who will be financially sound enough to do that? I think the only exemption is Yare because he's got an imperial sword. If after 6 years it is still not successful in acquiring the whole lot, then it can ask for a forced compulsory sale of the properties. Now, if you give the monopoly to Yao A, then you will delay urban renewal. This is not beneficial to residents living in the older urban areas of Hong Kong, and they have to pay a high rent, and they are waiting for public housing as well. So this is not just about the collection of stamp duty. This will have serious social implications. So Mr. Sheik's position is very clear. We will leave it at that. Mr. James Toh, before you arrived, there were a few rounds of questions with responses from the administration. Would you like to follow up? All right. Yes, I apologize. I have too many issues to raise. Regarding companies, I'd like to know whether examples have been given by the administration, examples of abuse. That is, companies owned solely by permanent residents of Hong Kong. Now, if these companies are exempted, all right, companies wholly owned by Hong Kong permanent residents, how many cases of abuse has the administration got? Any disclosure? Has the administration got any specific examples for us? I don't think so. Examples. I think this was discussed at previous meetings. CB 1893/1213/01. In response to questions raised at the meeting dated the 8th of April. So starting from para 7, we explained that shareholders and the company itself are two separate entities. And then the shareholding can be transferred using various means. So it's not really that easy for the administration to find out if there is a change of ownership. So that would be an incentive for people to evade BSD. All right, can I discuss with you point by point? Hang on, Ms. Wong, are you done? Yes, I am just repeating an old point. All right, 893, bracket 1, para 8. Starting from page 3 of the Chinese version. Such ways, second line, page 3. There is no liability or no responsibility for the persons involved to inform the IOD change in ownership. So please do not just. Now, of course, I may be more familiar with such matters, but I don't know about other colleagues. You cannot just brush away or intimidate us with only one sentence. For execution of trust, for instance. What is meant by execution of trust if all the shareholders are Hong Kong PRs? And if such a move is taken, what are the relative risks vis-a-vis the loss of shareholdings? What if I fail to recover my shares after doing this? All right, execution of trust, what do you mean? I am sure you have thought of the scenarios. Please do not just brush away our concern. Perhaps you need a separate paper for issue of new class of shares or declaration of trust, so that I can compare the risks, assuming that it is tax evasion. Of course, the penalty is imprisonment. But that aside, the person may suffer a greater loss in losing the shareholding than paying BSD. So you have to tell us, so we'll decide whether the risks are acceptable or not. So it's pointless or meaningless for you to just explain using one example or one sentence. Well, I'm not asking you to teach how people to evade tax, because your viewpoint may not be, because you do not allow that to happen. So you have to convince us using concrete examples. And then we'll agree that companies owned solely by Hong Kong PRs cannot be exempted. We have to conduct a very in-depth analysis and consider risks before agreeing to your view. Mr. Wong from ILD. Yes, we pointed out the possible risks. But it also depends on the consideration in the case in question, whether there is sufficient incentive. Now, we can't say that when the consideration is several $1 million. No, I'm not talking about the consideration, but the risks. And why can't you trace the possible abuses? And I like to compare the risk of imprisonment against the loss in revenue. Because in principle, I support your measures so as to curb speculation or to introduce demand-side management. I agree with you that priority should be given to Hong Kong PRs, but I'm not convinced that there are ways to evade your measures that would. So you have to give us some examples for the basis of our discussion. So what do you mean by declaration of trust? What do you mean by issue of new shares? Mr. Wong. The government's position is we don't want people to abuse the loopholes. So whether it is by declaration of trust, nomination, authorization, or issue of new class of shares, whether these are known new means or these are known means to transfer shareholdings of a company. Because by using such means, the original shareholders may no longer be in control of the company. As regards the risks, it's hard for us to quantify. Because if people in the market know this loophole, well, and they may use this mass market scheme to do it. Whether they will only adopt such measures when the consideration is high, it is difficult for us to say. It depends on whether the persons would like to evade a BSD and whether they think that this is a way, this is a means. So you're not going to prepare any paper for us? You just use this argument, issue of new class of shares. What do you mean by new class of shares? You have to tell us the class of shares involved, how they can be issued. Is it that no registration is needed and it doesn't have to be included in the quarter of shareholders. You say that the risks are high. You have to give us analysis so we will know whether the risks are high. Now, if you think the examples are not exhaustive, give us more examples and at least write 1 or 2 pages on each way of evasion. Mr. Wong Ting Kwong, let me try to clarify what Mr. James To is talking about. Will we throw the baby out together with the bathwater? Now, for BST transfer among very close members of family would be exempted. Now, transfer to someone who is not your close family, what will be the risk involved? I don't think people will be that silly. Will we be that silly? Will people do that? You have to analyze. Will people be so silly as to lose everything just for the sake of saving BSD?
I think other members have also made the same point. So, but your general statement cannot make people understand. While you say there are many risks, but we've said on many occasions, we've asked how large the risks are, and could you give some examples to prove that the risks are very substantial so that we are willing to accept your policy considerations? I think we've discussed this many times already. So we ask the administration to give us a paper on this. Mr. Chair, Madam Chair, could we ask the administration to go back to the submission from READER? READER suggests that even with this risk, they propose that all these could be made criminal offences if it's a case of fraud. For example, making a false declaration. So let's say for all these possible scenarios, A, B, C, D, E, where they might be fraud, then you could make them criminal offences. I don't want to repeat the points made by READER. The ministry is not willing to look at that. They are very stubborn. They insist that there are these risks, but they don't want to resolve the problem because it's too troublesome. I don't think that's the right approach to take. Mr. James To has highlighted the problem, and Mr. To asked the administration to explain the nature of the problem, how they arose. The developer know that there are such problems. They propose a solution, but the administration refused to accept and simply insist on its own position. I hope the administration will, look at the submissions and the papers. Well, I think the same point has been made many times already. Will the RRD or the administration provide us a further paper? I think members are not convinced by your rather general statement. We're worried about possible loopholes. And that's why members kept asking questions again and again. So please give us, a supplementary paper. Yes, Madam Chair. So I think we finished with our deliberation or discussion on this paper. Mr. To, I was asking you earlier because you've made several inquiries which the administration has already responded to. So do you have any further, question? I don't think well, I think I need more time to digest all this. It's too much already. All right. Basically, we have now, I think we've asked the Secretary to go through the papers and the correspondence, and these have already been discussed at earlier meetings. If there's still questions which members feel are not fully answered, I hope the government will give us a paper to explain to us in detail what are the risks that you're worried about. And I think that our next meeting will be appropriate forum for the Secretary to come and answer the question. For example, whether companies whose shareholders are all Hong Kong PRs will be exempted. And also the arrangement for redevelopment. What you're proposing is actually stifling redevelopment. What you're doing is to increase land supply and to curb the speculative property market. But what you are now proposing regarding the 6-year requirement may actually go against your policy intent. So I think basically we've dealt with all that now, and next we will need to go on to the clause by clause. Mr. Ibrahim Sheikh. Whether it's the Chamber of Commerce or the Law Society, I'd like to know how the Law Association respond to the explanation by the administration. Could they give us a paper then? Because these documents are very important. Because we're only given one side of the story. I've already asked the administration to liaise with the HCAP and the Law Society and so on regarding the technical details, and then come back and report to us. And the administration is undertaken to do that already, and that includes the Law Society. Right, we now move on to the clause by clause of the scrutiny of the bill. I beg your pardon, Madam Chair. If you want to force this through, of course, it can be done. I'm talking about the administration, not yourself, Madam Chair. But since so many of the questions remain unanswered, and the government is still considering all these issues, how can we go to the clause by clause? You're making a bad start here. And then the government would need to answer all the questions yet. I mean, with all these issues unresolved, how can we proceed with the clause by clause? Or even if the Secretary were to come, we may still not be able to resolve all the issues. Well, the problems can never be fully answered, but at least there will be some answers. But meanwhile, the government is only telling us that they are considering all these points. So how can we do the clause by clause? So I'd like to ask our Assistant Legal Advisor this. We've written to the administration, we've sent 3 letters, and you propose that we discuss them during the clause by clause scrutiny. So should we need to discuss those now? I suggest that we should wait until the secretaries come and answer our questions before we go to the clause by clause. Thank you. In my letter, I also referred to some technical points raised by the Law Society and so on, and the government said that they might possibly consider that. Policies are decided by members. I think we should wait until the clause-by-clause scrutiny of the bill, and the government may put forward for CSA. So I don't think we need to do it now. Madam Chair, if we go to the clause-by-clause, I don't know when we will need to move an amendment. I'm not Raymond Wong or Albert Chan. I can't. Well, every member has a right to filibuster. Well, you still need justification. If we go by clause, and I can't go back on what I've already agreed to. So I don't think there's any point for us to start the clause by clause. We only have an hour remaining. Why don't we give the administration more time to carefully consider all the points made by us? Yes. As a matter of fact, there are still many questions unanswered. Also, the Secretary has yet to come. And we also like to know whether or not you will be moving any CSAs. We would like to know what it would be your final decision before we go to the clause by clause. I think we can work more effectively that way. Well, in that case, we have to say that if the Secretary doesn't come the next time, members who have who have strong reservations about the clause by clause. So we definitely would need to, make an appointment with the secretary to come at our next meeting, so that they can explain to us yet their final political considerations. Whether we agree or not, we are still all entitled to move our CSAs. Anything further from our legal advisor? If not, we may now adjourn earlier than scheduled. So the meeting is now adjourned. The secretary will liaise with the Bureau and make an appointment for our